All right, hello everyone. I am, as Amber said, Stephanie Bowman, and with me is Kevin.
Hi, this is Kevin Adler. I'm also a program attorney at the National Council.
So today we're here to talk about parenting plans and what advocates should know. And so our learning objectives for today are to understand what parenting plans entail, identify concerns that may arise when considering parenting plans in cases involving domestic violence, and considering ways in which advocates can help survivors obtain parenting plans, it's a lot of P's, that account for safety. So we really, I think Kevin and I would really like to stress today that we are going over some of the basics of parenting plans, but this is really, this webinar is for a national audience. I believe many of you are from around the country. Please feel free to chat in where you're from in the chat box. But we want this to be a place where you can ask questions as well. See if you have if any questions come up during the webinar, please go ahead and type them into the chat box. We'll be happy to try to answer what we can and be able to. We'll try to find out any answers we don't have off the top of our heads. So yeah, so we just want to make sure to let everybody know that really we want this to be a conversation, which can be hard on a webinar, but that's our intent of going forward. So please keep that in mind and let us know. Feel free to ask questions. So what we're going to start off with is finding out a little bit about all of you. So we are going to have a poll that asks, there we go, that asks what your profession is. Domestic violence advocate, nonprofit attorney, private attorney, judge, mediator, survivor, other. Please feel free to post that in the chat box too if you feel comfortable doing so. Yeah, so we'll give you a few minutes, or a few seconds really, to log in what your profession is. All right, it looks like we have mainly advocates, looking like mainly advocates. A few mediators, a few others. All right, so that looks pretty good. So yeah, it looks like we have 16 advocates. We have, 4 others, 2 mediators. So yeah, there we go. That's what makes up everybody here. That we know that hopefully this will be a good place to talk about how advocates can help survivors who can't find attorneys. So we want to make sure who our audience is when we're talking about this stuff. So here we go. Why do we care? Why are we focusing on self-represented litigants? Why are we here talking about self-represented litigants and parenting plans? I think the fact that most of the people on the line are domestic violence advocates, sexual assault advocates, I don't have to tell you why we're talking about self-represented litigants. So many of the people that come through and that are seeking services are unable to afford attorneys, are unable to get that legal assistance in their cases. And so oftentimes advocates are the people that are there on the front lines working with survivors, taking them to court, helping them find that legal information, helping them figure out where they have to go to do what, and help walking them through that process. So no advocates can't practice law. We definitely know that advocates are one of the top places where survivors are able to get information. So that's why we are talking about this guide that we have made about self-represented litigants and parenting plans. So, like I said, advocates generally know anecdotally how hard it is for a survivor to find parenting plans or for survivors to find attorneys. But there is some data also that shows that 70 to 85% of litigants in family courts are self-represented. And usually it is not because they don't want an attorney, it is because there are financial reasons they can't afford an attorney. They've spent all their money already that they can spend on an attorney. If they're separating, they already have dealing with financial issues that come with separating the 2 households, so that can make it harder to be able to hire 2 separate attorneys for a divorce case. Legal aid oftentimes is stretched just thin as it can be already, and it's hard to find legal aid attorneys that can help or pro bono attorneys. And so what really has been seen in the legal world is a push with courts, with advocates, with legal aid to really look at how we can also help self-represented litigants, because it's stressful and confusing to go to court alone, and when we can't actually provide those attorneys, we have to find some way to address these concerns. There was an article in 2016 entitled Future of Legal Services in the United States, and it quoted a USC economist as saying that each year U.S. lawyers would have to increase their pro bono efforts to over 900 hours each to provide some measure of assistance to all households with legal needs. So just asking attorneys to take on pro bono cases is not going to meet the need. I think that, again, advocates are generally very aware of the fact of how hard it can be to get legal aid attorneys, not legal aid attorneys, but pro bono attorneys to take cases. And when you find a good one, you keep coming back and start feeling worried that you're overextending your ability to your relationship with them. So it can be a really, really hard road to find attorneys. And this makes it even more difficult when we're adding in domestic violence, which is a huge problem. We also have stats that show how huge a problem that is. Again, advocates know very well how huge of a problem intimate partner violence is. 1 in 3 women and 1 in 4 men experience violence. It seems to be present in over half of all divorce cases. At least 65 to 75% of disputed custody cases involve some sort of power and control issues. So that's why it's so important that we specifically look at self-represented litigants and resources for them in a domestic violence context. And that is why the Resource Center on Domestic Violence, Child Protection, and Custody embarked on a project to try to create guides for self-represented litigants that have experienced family violence to really help them walk through the challenges in navigating custody. We have created 4 publications already that are available on our website, www.rcdvcpc.org. These publications include 10 steps for presenting evidence in court, 10 ways to find help with your case, 10 things to know about family court, and how to gather technology abuse evidence for court. The first 3 of these guides are already available in Spanish as well, and they can be downloaded and printed from the website, or you can request printed copies of any of these publications through our website. In addition to each of these publications, we also have webinars on each of these topics available on our website as well. So they're designed to really help advocates walk advocates through the guide so that they have a better understanding of what is in the guide, so if they are using them with survivors, that they are able to help walk them through those. And we also are in the final stages of preparing a similar publication for self-represented litigants on child custody mediation and domestic violence, and it should be on the website in the near future. So look forward to that. That goes through a lot of the different issues and how when mediation is being ordered or when a party would like to try mediation, how to do that in a safe manner when domestic violence is a consideration. So that's just basically a rundown of why we have these guides and why we're talking about these guides. The parenting plan is a guide that will also be out soon, so we are just really talking about what's in there, how this helps, and really giving an idea, just an overview of the parenting plans and how to and what self-represented litigants need to know. So to start that off, what is a parenting plan? What are we talking about when I keep saying parenting plan, even though it's really hard to keep saying it with all the P's, it gets a little confusing. So we're talking about custody arrangements, we're talking about parenting schedules, it can also be custody and visitation schedules, and sometimes courts call them parenting plans. And even some places will have a bit of a form that you can use in order to lay out a parenting plan. But really what we're talking about is we're talking about a piece of paper or such that describes how parents will take care of their children and when they will spend time with them and who will pay for the cost of raising them. So it's just a detailed setting out, thinking of the little minutiae of how to have the children have a set schedule and to take into consideration everything that may come up to the best they can to start day-to-day functioning as two separate households. So who decides parenting plans? There's a really big push from courts and from others that parents be able to agree on a parenting plan, that they be able to come up with something together. And that's great when parents get along, when parents can safely co-parent, when parents can agree and have those conversations. As we know, when domestic violence is involved, that isn't always the case. There may also be, the courts may also push for a neutral third party to start out before a parenting plan comes to the court to decide. This could be a mediator or a custody evaluator who would then make recommendations to the judge about what the judge should order. And some courts will require divorcing parents, separating parents to go through this process. Usually if the court requires it, they also have some sort of exception or some sort of process to separate domestic violence cases from those. There are even some courts that don't allow any sort of mediation or anything if there is domestic violence in the case. And what's really important, if there is mediation in a case that involves domestic violence, and again, we have a guide coming out very soon that will discuss that in more detail, but the two main things really are to consider, does this third party, does this neutral party have training or experience working with domestic violence? And can this be done safely? Is there a way, is there a method to do this where parties aren't necessarily in the same room? That their safety, each party's safety is taken into consideration, that we're making sure there aren't unintended consequences of going through this third party dispute resolution. So the final say, though, in either of the two before, parents or neutral third party, the final say always comes to the judge, or the judge may actually take testimony and do the parenting plan themselves if it's really contentious, etc. So really it all comes down to the judge, and the judge making sure that the order, that the parenting plan is in the best interest of the children, that things are taken into consideration. So they ultimately hold that parenting plan. And it's important, we'll talk about that later too, that to remember that the judge is initially, in the end, is basically the person that owns that order and has the ability to change that order. So when parenting plans are a little bit vague or a little bit, when we don't think about the unintended consequences of the different parts of a parenting plan, we can actually increase risks to survivors of domestic violence. Too vague is, again, one of them that happens all the time. I don't know how many times I've seen or talked to, worked with people who the parenting plan has allowed communication, but only communication about the child. Well, when communication's being really abusive, and when there are constant texting, constant emails, constant calling, interruptions at work, all of that kind of stuff, allowing any communication as long as it's about the kids really isn't necessarily helpful enough. When we have vague orders in a lot of different parts of this, not just communication, vague orders lead to a lot of gray areas, and a lot of gray areas equal a lot more ways that an abuser can find to intimidate, harass, and control their former partner. So we want to keep that in mind. We also want to make sure that the order isn't encouraging the parties to micromanage each other, because that can also have, can go the other way too much in that sense. We also want to make sure that we are being aware of the context that this is requiring of parents. and Kevin will talk a little bit later, I believe, about exchange, maybe, and such, about keeping that in mind, like how are we going to have these parties make sure that we're not actually increasing the amount of time that the survivor has to interact with their abuser. And also considering information sharing and how that is happening. I know a lot of times we'll have a survivor who has a confidential address now that she's separated, but there's a lot of push and pull in the parenting plan, in the custody case to try to get that information to know where the children are going to be staying, and knowing where the children are going to be staying versus the safety of the survivor, the protective parent in keeping that information for their safety. Different things like that. Different things like knowing. There's a lot of things that a survivor changes or does when they leave in order to increase their safety, and making sure that we're not compromising any of that in the parenting plan. Even just having a set time where we all know where each other is can sometimes lead to the ability to follow to new locations, to follow to safe locations, that kind of stuff. So just keeping that in mind is another thing about risks of too vague of parenting orders. So again, some of this is a little bit kind of beginner stuff on the whole legal custody, physical custody. Many of you are probably very, very experienced with trying to explain these differences, give this information to survivors you're working with. So when we're talking about legal custody, we're talking about decision making. A lot of people just throw out the word custody, and there really are two different forms of custody, and some courts are even moving away from using these terms. So it's important to know what in your area, what your court is calling these different arrangements. But legal custody really is which parent is making the major decisions, not the little decisions like what we're having for dinner tonight or any of that little stuff. But we're talking about like medical decisions about medical care, decisions about where the child's going to go to school, decisions about religious activities. Those kinds of things are what legal decision making is about. And that can either be sole legal custody or joint legal custody. Sole legal custody means that only one party gets to make those decisions. Joint legal custody, which is highly preferred by the court, is where both parties have a part in making those decisions. So physical custody is oftentimes a little bit more what people think about when they think about the term custody, and this is what is oftentimes called parenting time, called different terms, and it really is just talking about which parents do the children live with and for how long. So we have primary physical custody would be where one party, one parent actually has the majority of time with the child. The other parent may have visitation, maybe supervised visitation, but one party has the main custody of that child, and the child is with them the overwhelming majority of the time. Joint physical custody is where both parties share custody. In some states, they really want that to be about 50-50. Some, in other states, it may just mean that they want substantial time with both parents. So that's also something to look for, how that differs in different states, different areas, but keep that in mind. And there's definitely another push in courts to really go for joint physical custody, to have that meaningful relationship between both parents for children, and that is in their best interest. Sometimes when the court may not feel that they're quite to that stage yet, they may start with primary physical custody of one parent and start with like supervised visitation, then move to a little bit of unsupervised visitation, then maybe we'll start with overnights, and then we'll get to the point where we can move towards joint physical custody. So just because there's an order, first order that comes out that says primary physical custody to one parent doesn't mean that the judge may not make a plan in there that actually graduates that to something else. All right.
All right, thanks, Stephanie. So I'm going to be looking at, if I can get to the next slide, we'll be looking at. We're going to be looking at topics included in parenting plans. This is going to be a lot of kind of disparate things that it's important to think about when you're structuring a plan. And there's different ways to go about this, but when you're an advocate, which I think most of our guests are, you're going to be thinking, what does the survivor need to be doing in court to get a good parenting plan? Like, what makes an effective plan? And as Stephanie mentioned, as I think I'm probably going to reiterate a lot, these plans need to be specific. Details are incredibly important. I would say in any plan, but especially in a domestic violence case, because it's a fair assumption that the people are not going to be able to agree on something, or if they do, that agreement could be the result of coercion. It's not the kind of thing that you want to be in the plan anyway. So a parenting plan, as it comes out of the court, needs to be very specific. This first slide is parenting time. This is the most fundamental thing. If your plan doesn't have this in it, it's probably not a parenting plan to begin with. Parenting time is the time that each parent is spending with the kid. That's what these plans are about. Can also be called visitation. Sometimes, a lot of the time the court will say, one parent's got primary physical, like Stephanie was just saying, which means the other parent is going to be assigned to visitation. But they're kind of just words. The fundamental thing going on here is the parent is spending X amount of time with each kid. And usually these will be set days on a general schedule. So I've seen plans that said, one parent's got the kid from Sunday to Wednesday, next parent's got them from Thursday to Saturday, something like that. There's a lot of details to that. We'll be going into some more details in the next few slides. That's basically what's going on here. Besides being specific, these need to take into account things like the parent schedules, like the kids' schedules. So usually kids are in school, so they need to be thinking about when do the kids get out of school, when do the parents get out of work if they're both working, that kind of thing. Anyway, we'll go into more details soon, such as on this slide. So holidays and school breaks. This is one of the first things to think about. And you can think this is something, it's kind of an exception to the general plan, because even when you've got a plan that's like, Sunday to Wednesday and then Thursday to Saturday, just for example, there may be good reason to break that up when holidays happen. And also school breaks. And these are pretty easily foreseeable. Usually everybody knows when spring break and winter break and summer break are going to happen. And parents often want to spend more time with the kids over then. The parents might have more time. The kids certainly have more time because they're not in school. And courts and parents will often want to split those between the parents. And there's kind of two approaches here. One of them is alternating, which would be to give, one holiday goes to one parent, the other holiday goes to the other. And that could be more appropriate for shorter breaks usually. The other alternative is to split them, which would be, splitting the holiday down the middle. So if the kids got like 2 weeks off for winter break, maybe give a week to one parent, a week to the other. Now this can be very fact specific. If they're going to be going out of the country or going on a trip or something, maybe it would be appropriate to give a longer break to one. But generally that's kind of how courts think about it. It's important to remember holidays that you might not immediately think of. One thing would be like kids' birthdays. So there might be you might need special provisions for a birthday. Another thing would be religious holidays. So depending on the parent's religion or the child's religion, there could be other considerations here. Like I used to have a lot of Muslim clients, and they would celebrate holidays like Eid, which don't even show up in the court calendars sometimes. So it's important for advocates and judges and everybody to be thinking about what do these specific parties need. Maybe they don't celebrate Hanukkah, they don't celebrate Christmas, but they're celebrating some other holidays that you might not immediately think about. So it can be very fact-specific. It can also be contentious if the parents are of different religions. I've seen lots of cases like that. Mm-hmm. So anyway, things to think about. Also think about each child, because a lot of times in these plans we're talking about multiple children, and the children are going to have different birthdays, usually. They might also have different school holidays, because it's possible they're going to different schools, either because they're different ages or because custody has been split in such a way that they're actually in different school districts. I've seen that happen. So again, it's just one of these things where you got to think about all the details and think about what's going to work for the parties and the kids. Vacation. This overlaps a little with the school breaks and holidays, and it's the same kind of idea. There's going to be set days each year when the kids are on vacation, or when the kids are going to be available to take a vacation with the parents. And this actually overlaps a little with a later slide on travel. But it's important to think about, what has the family done in the past? What are they going to want to do in the future? A lot of times kids and parents want to go on vacations together. And the courts need to think about, okay, how's this going to work? And the details are like which specific days each year can they go on vacation? What time is the kid going to leave? What time are they going to be back? Where specifically are they going to go?
Can they leave the state? Can they leave the country? Or what are these options? Like sorry, not to jump in, but especially when you have domestic violence in there, what kind of concerns might the other parent have, and what kind of things could the court put in place in order to address some of those concerns as far as a parent not returning with the child after they've left the jurisdiction or anything along those lines. So yeah, there's a lot that can come up on vacations that you wouldn't necessarily expect when you're just setting out a vacation schedule. Like, oh yeah, sure. You want to be as specific as possible and try to cover those while you're in there and able to set those.
Yeah, for sure. This can be particularly problematic when you've got parents leaving the country, particularly if they're going to a country that's not a party to the Hague Convention. I've dealt with a few of those cases before, and they are a huge mess. Even if it is a Hague country, it's a huge mess.
Oh, yeah.
Good luck if it's not. So that's the kind of thing to take carefully into consideration. And the slide mentions notice. And part of this is, courts will be setting these plans, but the vacation might not happen for 9 or 10 months. You don't know. And it's the kind of thing where you might not know at the 9 or 10 month point what airline you're going to take, where exactly you're going to go, what exactly the dates are going to be. And so an order could say something like, a parent's got a right to vacation in this limited time frame, but they've got to give proper notice at a certain amount of time before it happens of what the details are going to be. Things like what time the kid's going to need to be there, et cetera, et cetera. Just to make sure everything stays fair.
Definitely, because that's a lot of the stuff that people end up fighting about later. And then how do you get somebody to determine what you can do, what you can't do, about the vacation plans that have changed now? Having that kind of set out plan of how you're going to figure that out is really nice to have on the front end, as opposed to trying to argue it trying to get attorneys to argue for you with each other about who's going to go where. It can be really hard at the last minute or closer to vacation, and an added significant stress. So if there's any of that can be talked about and put into the parenting plan about how this stuff will be determined, that can be helpful.
Yeah, it really can. I've been the attorney in those cases. They are really bad. When it's the last minute and it's like, a month before they want to go, and you're trying to get in court with a motion, and then it's a modification, the other parent's fighting it. They're really hard to do. So yeah, the details, thinking about these things beforehand can save a lot of effort after the fact. It saves a lot.
We do have a question about that.
So we have a question. Lisa's asking, does anyone know what a victim can do if they are trying to take the kids out of the country for vacation and the other parent will not allow the children to get passports? This is ringing a bell in my head, and at one point in my practice I could have answered this because I've dealt with these cases. The court order can contemplate this. This is, out of the country things can be problematic to begin with, but especially when you're dealing with immigrant families, people will want to leave the country. Stephanie, do you know how this works?
So my main experience in this is actually the flip side of this. Abuser wants to take the kids out of the country, and the survivor doesn't want the children to leave the jurisdiction. And so then we would go and look at like a UCAPA or like the Uniform Child Abduction Prevention Act. Is there a way to get the passports held or anything along those lines? That kind of stuff. But so the other way, I've not actually had as much experience with trying to get passports for kids so that they can travel for vacation. But that's definitely something that we could look into and see about and get back to you. So yeah.
Yeah, I feel like I really should know this because I have worried about this kind of thing before. Yeah, so things to think about. Going more into more details. Oh, sorry, go ahead.
Oh, no, I was just going to say that some other participants fantastically have offered some suggestions of petitioning the court for the permission to do such, so to obtain those documents. So that would be a good.
Yes.
That's a good point.
You could certainly go to court for this kind of thing, but this is another thing to think about beforehand. Like if there's going to be if you're doing a parenting plan right now,
Mm-hmm.
and there's going to be vacation in the future, put in something about the passports. So then if one parent's trying to stop the passport thing, you can just say it's a violation of the order. Or the other way around. Like if you don't want there to be able to leave the country, put something in the order that contemplates it.
Definitely. It's easier to deal with it on the front end than it is, again, to go back and try to get attorneys to argue, to do this at the last minute before a vacation, to get in front of a judge, to have the judge order this. If it's possible to cover these issues ahead of time in the parenting plan, that helps significantly.
Yeah. So going more into the details, transportation and details of the exchange, these plans are always contemplating when there's visitation time, they're contemplating the kid switching custody between the parents, as in like temporary physical custody. And it's important to put down all of the details so that there's something that you can hold the parents to. You almost never want to say, make an agreement in the future about how to do the exchange, ever. In any case, certainly in domestic violence cases, that's really bad. They're not going to agree, and you're going to be back in court. It's going to be a huge problem. And it's also a source of more power and control for the abuser if he's in that position, because then he can deny it and say, oh, the other side was being unreasonable, and it leads to a bunch of stuff happening in court that you don't want to deal with. So this needs to be very specific. Like, who's going to make the exchange? Is it going to be the parents? When there's an order of protection in place, sometimes you don't want the parents meeting for these exchanges. So get somebody else to do it. Sometimes there's family who are available. If the kids are old enough, they might be able to get themselves to a specific point. I used to practice in New York City, so we tell them to take the subway above a certain age. But there are communities where that's not available. In fact, almost every community. So somebody might have to drive the kids somewhere. Where's the exchange going to happen? This can be at somebody's house or apartment. This can be at a supervised visitation and exchange center. Honestly, the center is probably the best practice if that's available in your community. It's going to be more of a controlled location. There's going to be records. There's going to be somebody there who's experienced with the kind of dynamics in domestic violence relationships that can affect this kind of thing. It should be a public location under any circumstance. Like, this should not be happening in, like, the back room of somebody's house. And I would discourage even doing it in front of somebody's house. It's better if this is happening at the local McDonald's or something. Someplace where there are people present, so it's less likely that violence is going to happen if the parents have to be there. And preferably someplace where there's security, like security cameras and guards, so that if something happens, there's somebody there to stop it, somebody whose job is to stop it. And also there are cameras to record if something happens. So you can always go back after the fact and subpoena that if you need it.
I've seen a lot of people try to suggest the police station, which has its drawbacks as well, because I've also read cases where the police officer says, well, I see those people there all the time, there's troublemakers. Like, they have biases because they see people at the police station all the time. They kind of think that they don't understand that they're there because the judge ordered them to exchange their children there. So those cases are always very interesting, but they always remind me of how many times I've seen in orders that exchanges being ordered in front of police stations. So
yeah, I've seen an awful lot of those too.
Yeah.
And depending on the community, that can matter more or not.
Yeah.
Like I used to practice in a place where there's a police station. Like, there are police stations everywhere, but they can be very different in more sparse communities.
Mm-hmm. And it also might not be safe for the parties to.
Yeah.
I mean, there are other considerations that could lead to unintended consequences of meeting in front of a police station. So that's also something to keep in mind about ordering that. But yeah, it's something I've seen a lot. So. Yeah,
because police station, it's a location that the people know it's going to be open probably 24 hours, and they're just like, okay, whatever, just go to the police,
mm-hmm.
and you're not going to have to pay them either. But you may have to pay a supervised visitation exchange center.
Yeah.
a lot of considerations, but I think that the most important thing is this has to be very specific. And this is, I think, the most crucial part of the order, like very specific dates and times and places, so that if somebody doesn't follow the order, you can hold them to it. And we're going to talk a little later about remedies. But if you want to be able to get any kind of remedy, the order has to be specific enough, or the plan has to be specific enough so that you can affirmatively say and clearly say that somebody violated it. Yeah. So next we're going to talk about contact with the children. This is more of a modern problem, especially when we start talking about video contact. And this is the idea that even when the child is in one party's physical custody, the other party may want to be able to talk with them. This can be important on both sides, because the survivor might want to be able to talk to their kid when they're in their abuser's custody to make sure they're okay.
Mm-hmm.
The abuser's also often going to want to be able to talk to the survivor, to the kids when they're in the survivor's custody for various reasons, including power and control. Again, the overarching theme, these need to be very specific. When specifically? Is there like a time after the kids have come home from school or after they finish their after school things where they can sit down for a minute and make a call? Or maybe like later in the evening when if one parent's working, then it's going to be after they're out of work and the kid's done with their homework or whatever. Kids usually, parents are going to have set schedules. Like you go to bed at a certain time, you get home at a certain time. So there should be a time in there where they should have the time for that. These need to say specifically when, specifically how long, and how it's going to happen. And how should mean, is this going to be phone at like a specific phone number? Now that phone number might not be written into the order. There might be good reasons not to put that into a public document. But it should say, like a certain party's personal cell phone or home phone, if anybody still has those. That should be in the order. If it's going to be like a video chat, it should say Skype or Apple Chat or whatever people use for video stuff these days. Video chats have certain risks, especially if one of the people, especially if the survivor's address is confidential, the video could give the abuser clues as to where they live. That's something to think about very carefully when this kind of thing's being ordered. Like, that's a real reason to favor using the telephone rather than a video chat. And there's an issue as to whether these are going to be more of an open-ended order or whether there's going to be clear expectations. And we always support, these need to be very clear orders. And there needs to be fairly clear expectations as to what's going to go on here. And this is something, we're going to talk a little later about, actually in the next slide, about communication between the parents. But the nature of the communication with the kids is also important. Like, it's the kind of thing where, especially if there's been a history of abuse, either for the other party or the kids, the court might want to order the abuser not to disparage the other parent, not to bring up other contentious issues. Like, what's the point of this call? And if the point of the call is just checking on the kid and seeing how they're doing, that should be the limit of the conversation. Especially when there's confidentiality. Again, the abuser shouldn't be asking the kid, okay, what address are you at? Or, tell me the color of the house that you're in. Like, those kinds of identifying characteristics should not be part of the call. It should be a violation of the order if they are.
Yeah, and I think that you've made some incredibly good points. I think that there's definitely I've seen a lot of communication that is supposedly about the parenting that ends up being disparaging, that ends up being intimidating. But hey, I started out with it being about Billy. So obviously it's about parenting. So it's within the order. That kind of stuff, you can see it happen all the time. Like trying to push those limits, finding those gray areas in the order, in the parenting plan, in order to try to continue or regain that sort of control, to reinstill that information, that harassment.
Yeah. This can be a real source of power and control, even when it's just talking with the kids. So that's really important to think about.
We actually also have somebody in the chat that's saying they are a director at an exchange and supervised visitation center, and that phones, calls, video chat are often used as a way for the offender to maintain power and control. So again, that just reaffirms that even even when talking to somebody at the exchange and visitation centers, that's happening. between families. So yeah, it's widespread that those are used. That there are easy ways to continue that sort of control, that sort of checking up. A lot of different ways that phones can be used. And we're not even talking about different apps or anything like that today. So it's important. I know that I've talked to some people, some court professionals who were talking about the fact that they're having a hard time with the court ordered one parent to have a cell phone for the child, and then now they have access to everything because they run the cell phone, they own the cell phone plan, and then how do you deal with safety planning around that? So there are so many different levels of problems that can come up when we're talking about telephones and video conferencing and all of that. But yeah, definitely something important to keep in mind and consider around parenting plans.
Yeah. Our next slide is also about communication. This is between the parents. And this slide, one thing to think about, we're talking about domestic violence cases usually. There is often a protective order. Most of the cases I used to work on, there was a protective order. And usually those things, if they say nothing else, they'll say no contact at the top, with maybe some exceptions. So if there's a no contact order, that needs to be preserved. And any kind of custody order should never be used as a runaround to get around the no contact order. Like, no contact order is supreme. And if there need to be exceptions, that can be written in. But the presumption should be there don't need to be. And that's one reason to make these things so specific. Because if the parenting plan is sufficiently specific, the parent shouldn't need to communicate about it. And there could be emergency provisions. There could be a provision like, if something, maybe under an extreme circumstance, if like something happened, the parent can communicate that they aren't able to go there that day, but it should be very limited. You'll see orders that say any communication between the parents has to be limited to issues related to the children. It is very easy for abusers to weasel around that and say whatever they want. If this isn't an order, abusers will often feel empowered to say anything because they'll say, oh, you're a bad parent, whatever, general disparagement, and they'll say, oh, it's about, your parenting and therefore related to the children. And it's going to be a fight in court down the road to try to say, well, it was about the kids, or well, it wasn't about the kids, and nobody wants to do that. This is why no communication is usually better. But there are cases where it's necessary. So when it's necessary, the court should be very specific about the precise kind of communication that's okay. And that could be only telephone, only text, only email, depending on the party's position, depending on the kind of technology they have available. This is so, especially when you're considering the survivor's safety, it's better if communication can only happen in one of these ways, or in a way that's other than in person. It's really important that, especially when there's a protective order, that the abuser not have the ability to say, oh, well, we had to communicate, so I just showed up at her house and started talking. And that's bad. That should not be happening. Even when there isn't a protective order, really, but certainly when there is. The terms of that order have to be respected. There are certain programs and apps, and Stephanie, I think, knows more about that. Stephanie, by the way, is also an expert on cyberstalking and cyber violence and all of that. Which I am not, and she can maybe tell you more about some of those. But there are different ways, like this, like WeChat and whatever, that courts can specify that communication should occur as a way to help protect the parties.
So, I mean, I can tell you that some of these acts labeled here, what they do is they allow other people involved in the case to see all of the communication that's happening between parents and makes it available to the court. It saves it for litigation, basically. Some of them even have, if you pay extra, you get a tone meter that tries to highlight when you're using language that could be considered aggressive or rude or anything along those lines. But so they're back in the day before this, I think a lot of times it was, CC your attorneys, or CC the case manager, or CC someone in the case so that somebody else is part of the conversation, so it's not just you two, fighting, like orders like that would get kind of pieced together. And so I think that these are ways to try to find a neutral third, an option for a neutral place where conversations, where it can't be edited, people can't delete, people, like, there's not the control to change what was said. It's when it was said, it marks all of that stuff. And the problem, though, is some of them are free, but also some of them do cost money. Some of the ones that do cost money definitely have programs for people who are represented by legal aid or who have other financial hardships to get access for free. So that is something to consider. There's still some issues that can always come up. The unintended consequences of some of the stuff can be is still kind of being worked through, but it is a technology that's out there that people are pushing in these situations. So it's important to be aware of it.
Yes, so technology can be part of the solution here if it's used appropriately. It's just very important to think about the repercussions of allowing any contact between the parties and trying to craft a plan that doesn't require that. Another thought I had, and this is, we talk a lot about pro se litigants, but if a party is represented by an attorney, it's a good idea to say communication has to go through the attorney, if at all possible. Like, I certainly did that when I was representing clients. I know most people don't get attorneys. This is mostly pro se. If that's available, it is really good to have in the order. So something to think about.
And if you can afford to have your attorney reviewing, if you don't have
Yes.
if you don't have somebody who's representing you for a discount, pro bono or low bono, it could rack up some bills. Having them review all your emails, so that's also...
That is a really good point. I'm kind of instinctively approaching this from the perspective of a legal aid attorney, so I was like reviewing these people's things for free. But yes, that could certainly rack up some hours for people who charge money for their services. Potentially a lot of hours, so yeah, something to think about. So first right of refusal. This is a fairly specific kind of thing. But it's something you can think about. And what this generally means, the slide doesn't explain it, what this generally means is a provision in a custody order that says if one party is going to be hiring like a daycare or babysitting services, they have to give the other party the right of first refusal to say, no, you can't use them, you have to let me come and spend time with the child. This is very problematic for DV if it's being used against a survivor, because this says that even if a survivor currently has physical custody of the child and they're getting like a babysitter or daycare or whatever, they have to give their abuser the right to come and hang out with the kid instead. This is not a good idea when there's been DV or any kind of abuse. It might be okay in other circumstances. You can imagine that this could save survivors some money in certain cases because they wouldn't have to pay the babysitter if the abuser coming over, I guess. But probably not a good idea. That's the main thing to think about this. We mentioned this because there are some courts that really push these. And you'll see these sometimes on those standard pre-printed parenting forms that Stephanie mentioned. You can just check them off or whatever. Probably shouldn't be checking them off. But if you are, think about it very carefully. And think about the possible implications for power and control by the abuser.
Definitely having that as courts thinking of that is a great thing is understandable when you're talking about parents that get along, that can co-parent. When we add in the power and control issues, the violence and such like that, it's easy to see how it can be manipulated to really enforce some of that.
Yeah, I kind of don't like it at all, honestly. If the parents are getting along, then they can just arrange this between themselves, like whatever. And if they're not getting along, then this is going to be a source of a lot of problems.
Very good point. Very good point.
But I don't know. Maybe somebody's found some use for these things. So travel provisions. We talked about this a bit earlier about vacation. This is travel provisions in a custody order or in a parenting plan need to be very specific. Specifically about, things about notice, like we said before, the vacations, things about where the party's going to go with the kids, where are they allowed to go, and this could be, all sorts of things, like out of the local community, outside of the city, outside of the state. Outside of the state is the first level where you start thinking, uh-oh, they're going into another jurisdiction. And there is the UCCJEA, so you don't worry too much maybe, but there's still things to think about here. Outside the country is where you start thinking something bad could happen. Because I've seen something bad happen a lot. I had an Egyptian case once that was, it took us like, I think it started before, it lasted more than 6 years. It took forever. Cases involving foreign jurisdictions are crazy. They're very difficult. They're very expensive to litigate. Courts hate dealing with them. Courts will personally hate you if you deal with these at all, because they're like, they won't know what to do. So think very carefully if there's going to be travel outside the country, and make the provisions very specific. Because the thing is, like, if a parent is allowed to leave the country with the child, you have to think of the worst case. And the worst case is they stay outside the country with the child. And what do you do about that? Well, a few years ago, I could have told you basically what you do about that, but it is really, it's not easy. And you're going to be involving, like, U.S. consulates, and you're going to be involving foreign governments and foreign jurisdictions that nobody you work with is going to have any expertise about, unless it's like Canada or something. But you know, those are not the worrisome cases. So I would think very carefully before you craft a plan that's letting people leave the country. And if you do, it needs to have a lot of details. At least make it clearly contempt if they're staying outside the country with the kid beyond a certain time frame. Good luck enforcing that contempt, but yeah. These provisions can allow for a lot of micromanaging, harassment, and stalking. And that comes up particularly when you've got any kind of travel provision that says, you know, parents need to agree down the road about how this travel is going to work. That's not good. These plans should not say parents agree down the road. These plans should say beforehand, you know, X party is going to have a right between such and such a date to take their kid to wherever for a certain amount of time, or for not more than a certain amount of time. But in order to exercise that right, the party is going to need to, within a certain time frame before that, provide certain information to the other party. Information like the exact dates, like the time the kid's going to have to be there, like where are they going to be staying. Be nice to have an address where they're going to be going. And that's something to think about either way, because if like a survivor is going to be going outside with the kid, maybe they don't need to give the address to the abuser. It's the sort of thing that could encourage harassment or stalking. But on the other hand, it's the kind of detail that could help limit more legal problems in the future. So this kind of depends on the extent of the violence. Like if it's the survivor going outside the state, going to a different address, maybe don't give the other side that address. But still a good idea to tell, they should still include at least the general jurisdiction, like I'm going to X state, or maybe to X city, if it's a sufficiently big city, you know. So again, detail is important, and limiting how much the parties have to talk about things is important. And making orders that are actually enforceable with contempt is really important. Other topics. Each of these kind of deserves its own slide, but we're just going to go through them really quick because we don't want this thing to take forever. Education. So, like I mentioned earlier, kids might be of different ages, kids might be going to different schools. Parents might have different ideas as to where they want their kids to go to school. I used to have a lot of Hasidic clients. A lot of them living in Brooklyn, and a lot of those parents would want their kids to go to these specific Hasidic schools that they have there. But there are other instances where you've got religious schools or specific community schools that one parent might really want the kids to go to, and the other parent might not. And I'm not saying how that should get determined here. That is way beyond the scope of this PowerPoint. But it's something that should be in the order. The order needs to make a determination as to where these kids are going to go to school. Medical care, as Stephanie mentioned earlier, this can be an important component of the plan. Maybe there's a specific hospital. Maybe there's, and it should mention health insurance. I don't know if we talked about that, but if the kids are going to be on one of the other parties' health insurance plans, that should be in an order of some sort to make sure they don't do something ridiculous like drop the kids off of it, because I've seen that happen.
Ooh.
It's bad. And that can tie into like where they can get care, because there's going to be hospitals that are in network, that kind of thing. Like, this is the sort of thing that should be in the plan. And there can also be issues as to what kind of treatment's going to happen. It's not a good idea. Again, it's not a good idea to have the parties need to agree on something in the future. But medical care is an area where courts will often do it, And there often isn't an easy way around it because you don't really know what kind of medical care is going to be necessary in the future. And you can limit it to some extent by saying, like if the kid's doctor, if the kid's primary care physician says something's necessary, the other party can't deny it, something like that. It's the kind of thing that can come up. Religion, like we mentioned earlier, there can be religious holidays for each parent, so take that into account. But also things like religious schools, things like which church or synagogue or mosque they're going to go to, when that's going to happen, what Sabbath they're going to celebrate. These are things to think about. Extracurricular activities. This is things like sports after school, other stuff that kids might want to do. This is going to tie in a little later into financial provisions because, in fact, I'll just talk about both of those because that's usually where this comes up. Usually, financial provisions come up in the context of extracurriculars or other things that aren't part of child support, which is on the next slide, but that might come up as an expense in the kids' lives. So if there's like a fee to be in the sports team or the Boy Scouts, the Girl Scouts, or whatever, the order should contemplate that kind of thing. And this is the sort of thing that it can be tricky for an order to contemplate because you're not going to have details before the fact as to what club the kid wants to join, usually. Sometimes you do, but most of the time you don't. And there could be a monetary limit on what a non-custodial parent has to pay. There could be provisions as to the sorts of things they might want to do. It's the sort of thing where you don't want to bind the kid to certain clubs before the fact, but you want to make it so that after the fact, once the kid's picked a club or whatever, they're going to be able to do it. Honestly, I've seen modification petitions just around extracurriculars, and this is because it's such a hard thing to predict. But something to think about, if it's possible to put into the order, if it's reasonable under the circumstances, it should be in there.
I think one thing to consider putting in there that's related to extracurricular activities may be for like recitals or games, can both parents go to those? Which parent can go to them? Is it if it's during which parent's time? Especially if there's a protection order in place, like thinking through some of those things might also be something to consider in the order or in the parenting plan, just so there aren't issues that come up again later when there's a big game and both parents want to show up at the game, but then one parent's staring at the other parent intently. Like I've gotten those calls the Monday after that's happened, and so so that's also something to consider.
Yeah, that's a really good point. Is that especially when there's a protection order, like games and recitals are places where the parties might end up being close to each other, and if there's like a provision where parties have to stay apart 100 feet, something like that, it's something to think about when the court's crafting these kind of orders. Childcare. We mentioned the right of first refusal before. That's probably the biggest consideration for this. But this is something to think about. Also related to financial provisions, so who's going to pay for the childcare if it's going to happen. If both parties are going to need it, then maybe both parties pay it. If one party's working, the other's not, then, I don't know, maybe they split it. It's something that should be in the order. Again, we're not talking really about the substance of what the order should say so much as the order needs to be specific as to how this works. Skipping down to relocation, this is not the same thing as travel because we're talking more about permanent moves outside of a jurisdiction. Not necessarily outside of a jurisdiction, but this is actually, I was researching this for another project, and this can be a big point of contention. State statutes vary a lot as to how they treat this, so this is something important to think on a state-by-state basis because some statutes will say the custodial parent, there's a presumption that they can relocate if they want. There are states that go the opposite way, say there's a presumption that they can't relocate. And I'm not going to say which of those I like more or not because sometimes the abuser's got custody. Sometimes you don't want them relocating if you're representing the survivor, or sometimes it's the opposite. So this is something that is there's going to be usually a default law in place that governs this. And the court and the parties can think about whether they want to modify that. Most orders I've seen don't really talk about relocation unless one party is already thinking about relocating. Usually what happens when I've worked these things out is if one party relocates without the other party's consent, then the relocating party might have to pay transportation costs for the child in order to make visitation still happen. I had a case where somebody moved a few states over from New York, and they were able to do it, but part of the court order was they had to pay for all the flights to do the same visitation as the kid had before. So the kid, same time, same dates as before, but now the kid's taking a plane twice a week.
So the burden's on the party that moved.
Yes.
Okay.
But that was part of a modification. That wasn't something we had in the original order. You could put that in the original order. If you're representing somebody and you think the other side's going to want to relocate, this is maybe something to try to get in there. Something saying, if a party relocates beyond, I don't know, like a certain distance or outside of a certain jurisdiction or outside of a certain community, that party is going to have to pay for making sure the kid is, well, for one thing, the same order is going to be in place. And that the other party is going to have to pay for and enable the kid to comply with the order entirely, with all the visitation, all the, whatever else is in the order. Something to think about if that's a threat, but not a common topic. Military provisions. I don't have a lot of experience with these, but, sorry, go ahead.
Oh, no, I was just going to say, I think that mainly what we're really looking at with that one is deployment's a possibility. How will deployment work? How will communication, will another third party, will a grandparent or another individual be also wanting time thinking through those kinds of things around deployment? Because military personnel and their deployment, there are definitely special provisions, or they're moved to a different location, all those things. Like, there are definitely different provisions in states for dealing with military families as opposed to non-military families. So that's something to just be aware of and to keep in mind.
Yeah, I think both deployment and relocation, because sometimes people get swapped around, have to go to a different military base across the country, and what do you do? So especially if one parent or both parents are in the military, that's an important clause to think about. Or if one's thinking of joining, then maybe think about that. Non-disparagement clauses are the last topic here. These are a pretty good idea. This is something that it's not really a bad thing, and you don't really want parents disparaging the other parent. It can be tricky to enforce, in my experience. And a better clause, if you can get one, is no contact. But sometimes the parents need to communicate. So if there's going to be communication, it's a good idea for the court to order no disparagement, or even no disparagement to third party. That's the other thing, because they can, especially when there's kids involved, one party might want to trash talk the other parent to the kid, and that shouldn't be happening in either case for either parent. So clauses are pretty good. Although they can, again, be used by the abuser against the victim by saying, oh, well, you're disparaging me. This actually has some overlap with parental alienation for people who are familiar with that topic, which I'm definitely not going into today. But these can be, well, there's something to think about when crafting the order. So moving on, we're going to talk a little about child support. This is the only slide we have on this. This is another major topic. I've done trainings on this before, but detailed trainings on New York law. These are very case-specific, or very state-specific and case-specific. States usually have particular laws about how this works. Back in New York, it's a formula, as it says in this slide. In most states, it's a formula. It's going to be a percentage of the parent's income, and usually with some relationship to the amount of time spent with the children. And then there might be some factors that either party can use to try to deviate from that. Child support is a huge contentious issue. Even when you've got formulas in place, you've always got people who are saying they're self-employed and hiding income, or who are employed and are hiding income. It can be really difficult to get a good order here, and it can be difficult to enforce. It's one of those areas, we used to talk about this a lot, it's kind of catch-22 when you enforce these things. Like if somebody's not paying child support, you can take them to court, and you can get an order saying, okay, better pay your child support. And if they don't, you can potentially put them in jail, if it's serious enough. But then they're definitely not paying child support because they're in jail. They're not making any money. It's the sort of thing that you want to be able to threaten and be like, we're totally going to put you in jail, but then you don't actually want them in jail. So, you know.
And also working with, having worked with a lot of survivors, sometimes not getting child support also coincides with the other party not trying to exercise visitation. And so sometimes it's a kind of weighing of that issue for the survivor. Do they really want to push on child support if that means that the abuser could then push about more access to the child? And so sometimes it's also kind of a weighing of that issue and whether or not what's more important to the family in that sense.
Yes. Yeah, that's a consideration. Usually these orders are going to be separately enforceable. One expression we would used to use is it's not pay to play. You know, whether or not the visitation's happening, you got to pay the child support, we would say.
Yeah, well, yeah, no, I'm not saying...
No, I absolutely understand what you're saying. Like, I know, like, it can, like, if the abuser is currently not involved and not doing the visitation, and if that's something the survivor wants, and if the child support's not that much, you know, maybe not that big a deal. I also used to deal with this often in the public benefits context, because if anybody's done some of that, you may know that under federal law, I think, and certainly under most state laws, if a party is getting public assistance, then the right to get the child support gets assigned to the public welfare agency. They'll often bring these cases for the survivor, which can also be a problem. There are ways to get waivers of that. That's a whole other training. Forget I said anything about that.
Yeah.
I want to talk about that, but I'm not going to. Also,
but we don't have time to go into that one.
Anyway. Yeah, so.
All right. So we are going to go over modification and enforcement really quickly. Modification of parenting plan. So if we're just talking about we're going to switch, you're going to take this weekend, I'm going to take next weekend, or, you know, can we switch Thursday or something like that. It doesn't need to go to the court necessarily, but you do want to try to have that in writing. And by writing, I mean, like, you want to have a text from them, you want to have an email, you want to have some sort of documentation that this was consented to, agreed upon. And that's really for, like, those occasional changes. If you want to significantly modify the continuing parenting plan, you can do a joint petition if both parties agree. That's a little bit easier road sometimes, often. So that's something to keep in mind, that if parties agree, it's a little bit easier to get that modification, but you still want it signed by a judge so that it's enforceable. Otherwise, the court is going to consider the old order as being the enforceable order. You may be sent to a neutral third party, but again, that can have different issues when we have domestic violence. If we're going to the court, though, and parties do not agree and they want to change the order, what they're really going to have to do is they're going to have to motion to modify, and then they're going to have to show why there's been a substantial change in the circumstances in order to get that change. So they have to show that something substantial, again, it has to be substantial. It can't be just a small thing that's changed, that they want to now have Fridays instead of Mondays because of X or Y. It's got to be a substantial change. And I don't know, like, what is considered a substantial change. Right now I just keep saying that word and that doesn't help define it, but it really is state specific as far as how that's defined. So that's something to look at in specific states as to how the court deals with that and what they consider a substantial change in circumstances.
Yeah, we were talking about that earlier. It's kind of case law and practice, and it's not a very specific term.
So enforcing parenting plans, and this is really one of the, we'll get you off here soon if you're coming. Sorry, I was reading something off screen. So when we're talking about enforcing parenting plans, we're talking about parenting, how we get this, you know, how, if somebody's not doing what they're supposed to be doing, not dropping off the kids when they're supposed to, keeping the kids longer, anything like that, how do we actually go and get the order enforced? There are no parenting plan police, so nobody's going to be there making sure, okay, the kid got home at 15 minutes late, so the order was violated, so now, nobody's going to be checking and making sure, nobody outside of the parents are going to be checking and making sure that that's being followed word for word. If a parent is not complying, that really is going to come down to having to go back to court and motion to show cause why they are in contempt. And contempts get really, really complicated in a lot of places, and so it's something that definitely varies throughout states, and so that's something, again, to look at how that enforcement happens. But it's really going to take oftentimes going back to the court, even in a lot of places going to the police station, whether rightfully or wrongfully, under their statutes. Police will say, this is a civil matter, this is a family matter, we can't do anything about that. There may be places where, like courts can actually issue orders that police can enforce out of a family case. That happens a lot, but you often, even when you get those, you get the pushback from law enforcement. No, I can't do anything about this. This is a family matter. You got to go back to the family judge. So that's something to keep in mind, that even if there is a remedy, that it may be you're getting sent back to court to do a contempt or to do a modification of the parenting plan based on the fact that the other party is not following the current parenting plan. And the other possible ramifications that aren't on here, as we mentioned, contempt, and that can be confusing and to try to carry out, and oftentimes that's a party trying to bring that. But there also are some states that have different laws that significant time of not sharing the children, of not producing the children for visitation, or not returning the children from visitation can be considered interference with custody or parental kidnapping, or may fit in those kind of cases. So that's also something to consider as a possible ramification, as and possible consequence of a parent not turning a child over. So, that's...
Yeah. And this is it's a very tactical kind of thing when you're thinking about how to enforce these. Like, there's a lot of potential remedies, but you got to think about, and basically in every case, it's how much is this source of authority going to care? And like the police generally, in my experience, don't care a lot unless it's something pretty extreme. The courts also don't care a lot. Depends on the judge you get. This is very state practice specific, but if they miss one visitation day and you run to court the next day with your order to show cause, the court might not be too happy about that. They might think that you're wasting their time. You might be wasting their time. So,
So yeah, it's definitely strategic to think about, how am I going to bring this? How am I going to show that this is something that wasn't just they forgot what time we said or anything along those lines, but making sure to show why this is an issue. And I know we've kind of flippantly in some places been like, you can put it in the order, it may be hard to enforce, but that's because, it takes more time and it takes going to court again. It's better than not having it, definitely. But yeah, there's also some real realities. There's some realities to the idea of trying to enforce these. It's going back in front of the court. It could take more resources, it's time off work, that kind of thing, to make an argument to be able to have the court do something. So yeah, it can be very frustrating, but it's the system that we have set up, and that's how. Yeah, I don't have any big solution for that, unfortunately. I really wish I did, because it would be a lot easier. So moving on real quick, because we are very short on time. So the last two slides are really just about how can parents prepare, and what we're looking at when we're talking about how can parents prepare. These lists that are in the PowerPoint, they're really about what a judge would consider, what judges in states oftentimes consider when looking at parenting plans. So in order to think about a parenting plan, it's also good to know what the ultimate decider is going to be thinking about. So just to cover these real quickly, and we've already talked about a lot of them in a more detailed manner as far as issues, but just in general, making sure that safety considerations are taken into account, that child's needs are being met socially, emotionally, physically, what school environment is the children in, do they have extracurricular activities that are they connecting with the community, is there that kind of bond, is the children's ability to adjust or change, or is there a need for stability? So are we changing too much of their plan? Like, is this plan changing too much of what the reality already is? Is it creating something unstable and unhealthy for the child? What is the physical distance between the parents' homes? These are the different kinds of things that are how a judge might look at them. They're thinking about the same things we've been telling you about to include in the order, but they're like how the judge might think about those sorts of issues and how they might consider, okay, you want them to go to this school, you want them to go to this school, but where do they feel comfortable, where are they involved, where are they engaged, maybe decision or maybe factors that judge or arbiter uses to figure out whether or not, which option they're going to choose to go with.
Yeah, there's a lot of things to consider. This could be, there's just a lot of things to think about. Your parent schedules, I think we mentioned some of this before, whether there are any non-parental assistants, although courts should think carefully about who that person is. Like if it's, a member of the abuser's family, maybe that's not going to be the best third party.
Maybe they aren't as neutral as we would want. Yeah,
neutral is an important part of being a third party. Parents' history of an ability to work together, so, in a DV case, that's not going to be there. Probably same with the one after that, handling conflict. Substance use, definitely had a lot of cases with that. Parents' role in child care before the separation, this is something to think about carefully. It's like think about the extent to which you want to preserve what was going on, but on the other hand, maybe that's not going to work. It's the kind of thing where, maybe even though the survivor was like a stay-at-home mom beforehand, maybe they're going to have to work now because they're splitting up, and childcare kind of sucks. I mean, child support and childcare.
Yeah, and this may be a place, again, too, where it's not that that's a determination of who gets custody or who gets, hear me talking about just custody in general, like but no, who gets primary custody. It's maybe one of the reasons why you may have like a graduated kind of situation where if one parent has really solely been responsible and the child does not feel fully comfortable, I mean, not because of safety considerations or anything, but maybe there just isn't that same sort of bond and relationship, then maybe it would be gradual moving towards more joint type of custody. But so even, I mean, that's not necessarily going to be something to consider necessarily as far as not having joint custody, but it may be on how we kind of move the child towards spending more and more time with the other parent in a way that is most helpful for them.
Yeah, absolutely. And again, finally, relationship with other family members and children's preferences above a certain age. And that can be sometimes governed by statute, sometimes it's up to the court's discretion. But, it's something that I think is very important to take into consideration, like what does the kid want? And this is something people often lose sight of on these custody battles.
Yeah.
So, where can survivors get help crafting parenting plans? Well, there's us. You can go to our website, listed here, and look at our resources, and they're really great. You can also go to a self-help center, legal services provider in the community. This is, again, very location-specific, but there's a lot of these places where survivors can go to get help.
And a lot of those places, a lot of those self-help centers, a lot of the, even some legal services providers can help with, especially like the child support forms. Those formulas can be really hard to do on your own, but a lot of places will have their software that will help calculate that, and a lot of times that can be available for free through legal services or through self-help centers at the courthouse or elsewhere in the community, libraries and such. So it's good to know whether or not there are those resources out there so that survivors can show up with a child support worksheet, et cetera, when the court is wanting that. So
yeah, there's a website we used to use that would do it for New York. Back when I practiced there. So, final thoughts. Every family is different. Every plan should be different. There is no one-size-fits-all parenting plan, especially when there's domestic violence. Your court's got to take a lot of things into account. And this is, again, what we've talked about is not exhaustive, but it's just a lot of the major things courts should probably be thinking about. I just noticed we have a question we'll start to answer quickly. What is the age that a child's preference is taken into account by the court? This varies a lot. Sometimes there are state statutes that say above a certain age you start carrying. Sometimes there aren't. And sometimes the court's just like, the point at which we think this child has like a reasonable sense of self and a reasonable vision for what they want, which could be, I don't know, I can't give a number for that. It's a difficult question.
And how the court would ask for those preferences or find out those preferences can vary as well. A lot of courts that may be where the judge takes the child into chambers and talks to them, so that they don't have to try to tell in front of both parents where they would rather live or anything like that. So there's a lot of considerations that go into considering a child's preferences, but they definitely vary from court to court.
Yeah, and there are jurisdictions where the child might get an attorney or an advocate or a GAL appointed for them who can represent their interests to the court. So there's no one-size-fits-all parenting plan. Survivors are in the position to know what will work and what will not work for their family. So again, the court should be listening to that. And at the forefront of every decision should be the safety of the survivor and the safety of the kids.
All right, yeah, that's it. And we are over on time, I think. So if you have questions, we're happy to answer any questions. Otherwise, feel free to reach out to us with any sort of questions you might have. That's not our email address at the bottom, but that is, you can email fedrinfo@ncgfcj.org, or go to our website, rcdvcpc.org, and contact us. So that's, please let us know, and we will try to help out in any way we can.
I just noticed we have a quick question on parental alienation. We do have some resources around that, and reach out to us, and we'll talk to you about it.
Yes, we're definitely working on that issue because it keeps coming up. It definitely keeps coming up.
It is a perennial problem. All right, well, thanks, everybody.
Thank you.